Good morning, everybody. Welcome to episode 44 of Cannabis Live, brought to you by the Cannabis Legal Group. I'm Craig Aronoff, along with my colleagues Copenhaver and Nick Galendez. Good morning. We, like every week, are here to talk about Michigan's medical marijuana market and all the things that have to do with the new cannabis industry here in Michigan. We actually have had the pleasure of going to Denver recently to meet with our colleagues with Vicente Cedarburg, and we'll talk a little bit about that today. Got a big agenda item in terms of the update from the board meeting yesterday, and just talk a little bit about the application as we do each week, and try to provide some advice on some parts of the application. Today we're going to talk a little bit about technology plans, and with that, what we'd like you to do is like us, share us, make sure you're engage us. If you have any questions, feel free to ask them throughout the show today. We'll do our best to answer them live. If not, we'll do so afterwards. Look for us at cannabis-legal-group.com, and there's also a link here on the page to our YouTube site where you can see our other 43 videos. We've covered a wide swath of the various aspects of Michigan law and some changes we've seen in the last year, and so we truly invite everybody to see that and comment and participate. So I suppose with that in mind, yesterday's, or was it 2 days ago now, the Bureau of Medical Marijuana Regulation and the Licensing Board met, and they reviewed a number of applications. We actually have some positive news from that. Nick, why don't you dive in and tell us a little bit about the good side of what happened the other day?
So yesterday the board met. They reviewed 12 Step 1 applications. We also kind of got some updates on Laura as far as the application process, the number of total Step 1 applications, as well as a kind of breakdown of the Step 2 applications that are completed. Also kind of got a few helpful updates on compliance bulletins and other good kind of tidbits from the board.
That's great. So Travis, we've seen now some metrics from the board. So they've reviewed. And we know that, they approved 9, they denied 2, they tabled 1. Talk a little bit about just the commentary, I suppose, on the approvals. What was the overarching common theme about them all?
Right. Well, just like in the last round of applicants that were reviewed, the big takeaway is disclosures. The board is very, very into making sure you disclose what you're supposed to, and if you fail to disclose something that you're required to, it's going to be an issue for your review. I think it was brought up in every application that's been discussed so far. Unless you disclosed everything you were supposed to, you got streamlined right through. But if something appeared to be missing, even if it wasn't, it was discussed. If something was missing, the conversation was about, well, was that intentional? Did they knowingly fail to disclose something? How important was that to the ability of this board to make a decision?
Mm-hmm. And I think also, too, what we kind of gleaned from it is that there's, kind of 2 parts here, maybe 3 parts. It's what's on the disclosure, what's actually on the form and the way the questions are asked. And then there's the second part with the background checks. They'll run that. Things might pop up that necessarily weren't included, but that they may have questions about. And I think in one of the applicants we saw that where there was a civil litigation, kind of something that popped up. But then the Attorney General's office clarified that, that wasn't something that was supposed to be there. But I think that definitely, as far as if you know something that isn't necessarily supposed to be disclosed the way that they ask it on the application, it's important to kind of be proactive and create a narrative to explain it a little bit, but also note that maybe this doesn't qualify as one of the questions that are asked, and I don't have to disclose this, but I'm being fully forthcoming and transparent and explaining it.
So I just want to take a step back before we dive further into the mud on it. But, first and foremost, each one of these board meetings is a learning opportunity. So anyone watching or anyone who has, been paying attention to the board, the details that we're getting from that and the minutia of that is very important. So we're starting to see metrics. We as attorneys are asked by a lot of different clients and prospects and leads, hey, what happens under this scenario or that scenario? And each time we have to kind of, put a caveat on our responses saying that we don't know exactly how the board will respond to things because other than making the decision of the next meeting and now these 9 applicants, we really haven't seen them make decisions until now. And so we have some more metrics to go with. So as we talk to you about, things that we're seeing, keep in mind that there's an evolution to how this board is going to react to facts in front of them. And we just have to be fluid enough to react and knowing that we have other applicants that will come in behind it, we have opportunity to secure and supplement applications moving forward. Now, with that comment in mind, a supplement might be deemed apparently by the board as saying that we recognized a deficiency before, and was that intentional or was it, not?
Right. I think you have a huge advantage if you're not one of these first few rounds of applicants, because every time we hear them discuss each application, we learn more and more about what they're looking for, what matters to them, and what you need to do. At this point, if for applications moving forward, you basically disclose everything you possibly can, and you explain to the board why you're disclosing it. If you have litigation, you should explain, yes, there is litigation, and here's why I don't believe it qualifies for what you need to see, is the better play than leaving it off the application.
Right. I don't think it's for the client or for even the applicant, us or anyone, to really decide, well, they definitely don't need this. At some point, if you're questioning whether they need it or not, you're better to disclose it and then provide an explanation than to fail to disclose it and have to answer to that. Because I think that's what we've seen so far has been a serious negative for those that have gone through it. We knew that from the last meeting. We know that from a couple from this meeting. Even the ones that, a couple of them that were approved, still had to answer to things that were, seemed inconsequential or seemed like they wouldn't have been as important to the board.
And I think one of the criteria that the board has to take into account, and one of the reasons why they can deny applications, is if they believe that the applicant knowingly submitted false information to the board. And that's kind of a subjective, feeling between the 5 board members, but I think those disclosures and deficiencies kind of raise those red flags sometimes, and it's definitely better to be safe than sorry. And if you include those up front, there's less flags and things that come up in the background checks that they can maybe latch onto that criteria and reason to deny an application.
Yeah, there's no doubt, and of course, it seems as though that there's a component of the board that might view every lack of information as intentional, as opposed to maybe giving the benefit of the doubt. And as we've met with clients and gone through, I can say firsthand, and I'm sure both of you can as well, that clients unintentionally forget things. There doesn't seem to be the meaningfulness behind it, but rather just forgetfulness. And so our job has been to really dig deep and try to walk through with our clients as we prepare those applications, to try to remind them that there might be something that happened 20 years ago that, oh yeah, we forgot. Let's make sure that's in there. Another item is if you can't find the information for yourself. I've heard from people that can't find their criminal history because it's so old. There's no court record available or readily available. Even their attorney's offices have purged that data relating to it. And so what advice would we give that person as far as supplementing and adding to that package?
Well, there are some challenges with that in general, but if you know what states that incidents could have occurred in, there's usually some sort of criminal history database that you can run. In Michigan, it's called an iChat, an internet criminal history tool, basically. And
that's also where you can write a letter too. I mean, and Laura's been very clear about it. If you can't find it, tell them. And so there's an applicant that I submitted recently where we couldn't find it. It was 22 years old. He knew generally it was in the spring of that year, 96 or whatever it was. And what we decided is we contacted Laura to ask, listen, there's no court records, we can't find it. Right. They said, write a letter explaining what efforts you made to find it and generally what happened with that. Yeah. Because the likelihood is it'll still show up on the background check.
And I think too, moreover, that extends not just to criminal history and civil litigation, but obviously properties, different financial institution accounts. I think that it's kind of not playing hide the ball here. It's really being forthcoming and opening up your whole books to Laura and the state, just so that nothing comes back in a background check that you didn't disclose.
Yeah, and Barton makes a good point in his comment that he added here, in that maybe every supplemental applicant really should submit themselves to an FBI background check. It may slow down the process for the application and submission. But what it also do is ensure completeness, and if you're able to look at what the state will look at, maybe there is something you forgot about. Maybe there's that old misdemeanor for minor in possession you got while you were in college 20-something years ago, and you kind of let it flow through the back of your mind.
And beyond that, sometimes those records aren't guaranteed to be accurate. You might find something that the state will think is in there that shouldn't be.
That's right.
So there's a lot of value to that. you really have to measure your expectations, like taking a little more time to go through some sort of private background check process to verify what's out there might take more time before you're ready to submit your application. But if you submit that application without knowing, if it's complete or not, you're going to have a longer time to wait should the board deny or question your application. You see applications already being tabled or denied and have to go through an appeal process. Well, we see how quickly the state's moving through their hundreds of applications so far. We've done less than 20 so far. So if you have to sit in the appeals, you're probably not going to be first on the priority list of having your appeal process when we're still waiting for initial applications, especially knowing several of those temporary operators need to have some sort of decision made prior to June. You're clearly going to be moved out of priority. So, the more accurate of an application you can submit, at least from what we've seen so far, is going to be the determining factor of how quickly you're going to get through this process.
I think that's very true, and it really goes to the other point, which is that LARA itself is creating its own efficiencies. LARA is working on that, and anyone who's opened a business or started a new project, the first few reviews of that are going to be slower than later on when you're more comfortable with the data set. So the analysts at LARA that are taking some time today, if they're doing 2 or 3 a day, it's probably not unfair to think a month or so from now they'll be doing 5 or 6 or double or triple what they're able to do and output. And so as this whole industry, this is brand new, nobody there has ever done this before. And to that end, it's important to give them that space to get good at what they're doing as well. Right. But our applicants also have to provide, understand too that that's where patience comes in, because it might be to your benefit to give them that time to get better and then be in the process versus these first ones that are, there's a lot of information that came out, I think, at the meeting the other day that, quite frankly, was curable and was, in hindsight, those operators could have probably made it a smoother process. So we have that for the future operators that will go through this process. They gave us some other metrics as to where everybody's at. And why don't you summarize for us a little bit about what the numbers look like from the state right now?
So there were approximately 470 paid Step 1 applications, and they gave the number about 78 municipalities that had opted in. As far as Step 2s, though, there was a more significant breakdown of the numbers. There's 9 Class A growers, 2 Class Bs, 49 Class Cs, 25 processors, 67 provisioning centers, 6 secure transporters, and 4 safety compliance facilities.
So we will have all 5 if at least one in each category gets through. So
right.
In theory, we'll have a functioning system if we get at least one in different places throughout the state.
Right, and so at least that's the beginning of the process. Now, of those, few dozens that are in this Step 2 process, we only had 9 approved yesterday, and I don't know that they were all pre-quals. None of them were actually Step 2. So we haven't quite seen exactly what the state will be doing as far as inspecting and challenging things like your technology and your facility plans and holding you accountable to what you wrote and when you submitted those applications, both at the state and the municipal level. As we talk a little bit later in today's posting, we are going to be talking about a technology plan and breaking that down. And we've seen in past posts with the facility plans and everything, these are very detailed. And our understanding is that when the state's going to be reviewing that end of it, it's going to be holding you accountable to what you said you would do,
right?
Not, something that just passes the muster to file it and then hope for the best.
Right.
Brad, you were asking about maybe getting a merged credit report in addition to your iChat report. It can't hurt. I think at this point, more information is better. And, for a negligible cost of pulling a credit report, you can ensure that any defects you may have in your credit history are explainable. Again, while there isn't the invitation specifically in Step 1 to do things like a bio or do things like, providing the information on a credit, why you might have bad credit, we still can add it. We still can find places within the disclosures to add that supplement.
Right. I think in general, if you have questions about like being able to feel confident in how complete your answers are to your Step 1 process, using tools to help go make sure you're shoring up those answers is great. Now, not everyone might need to run an iChat on themselves if they know for a fact they've never had an arrest by a police officer. maybe people might not need to be too concerned about their credit report if they're not worried about it. But if you're in a situation or one of your supplemental applicants part of your group are in a situation where they're not sure, then yeah, use the tools available to you to supplement your answers and make sure you get to a point of confidence.
And just because it was obtained doesn't mean that it ends up being submitted or used. I mean,
Right.
more information before you deal with the state, it will help you screen that and will help us,
Right.
kind of fine tune it so that we have the most complete and the most accurate, application on submission versus dealing with deficiencies. I thought it was notable too that, there were some comments made that curing the deficiency was actually negative. In other words, they were viewing that as like, oh, you must have known it was intentional or whatnot. You saw that in the meeting. Why don't we talk a little bit about what impact that could have on people?
Yeah, I mean, as far as whether there's what you disclose and then there's how you respond to anything that they might have said you didn't fully explain. And again, I think it's, being humble, being honest, having tact in what has happened, whether it's criminal history, your civil litigation, and fully explaining it and not saying, I said it didn't happen, or
I didn't think you signed it. That was one that we know of, right?
It's kind of, they're going to know it's there, and again, just kind of going back to the proactiveness of the whole application process and making sure you cover all those bases and more. There are several criteria that they can permissively, have the option to deny you under: character, moral integrity, business probity. I think that goes to credit reports, just kind of your general character that you could definitely supplement in addition to what's on the application and the disclosures. That'll kind of, pad up your application and make it more successful.
Well, I think it's very clear that, despite whatever report comes out of the Medical Marijuana Regulation Bureau that is doing these checks, and then they're giving the report to the licensing board, the licensing board will have its own set of questions and concerns independent of that report. Mm-hmm. And so, again, disclosure is key, truthfulness, and, at this point in time, it just seems like, at any point in time that you can provide additional information that would be helpful to the understanding of that background, that's important, then own the issue. If there was something that was, unintentionally left out, own it.
Right.
Explain it. Say why it was forgotten or whatever else.
Which goes to our question we just got about what happens with cannabis felons. I think it's all about your delivery. Like if you try to minimize it or downplay it or maybe not explain what happened, I think they're going to treat that, differently than if you own up to it. Like, yes, this happened. Yes, here's what happened. Here's why. Here's what happened as punishment. Here's how I learned from it. Here's why I think I still am okay to be qualified moving forward in this particular application.
And I think in there too is also say what you've been doing since.
Exactly.
People have had stupid things happen when they were younger. We've heard that a lot. There's a group of kids that got, busted by a cop at a concert, and they were 18. But since then, they've had great jobs and they've done a lot of good things. This is the opportunity to kind of own it and then explain how that's actually improved your life from the lesson you learned from that. And so that might be a good way to kind of, cure the issue, at least as far as the negative impact it'll have.
Exactly.
So, the board will be reviewing more and more applications. We're going to, each one is a data set. Each one of those, a piece of information is, important to us as analysts that are trying to figure out what we should be looking for and concerned with, and sharing that with our clients and those that are out there watching these videos and whatnot. We'll do our best to stay up on top of it. Certainly, if you have questions specifically regarding any of that, feel free to reach out to us at Cannabis Legal Group through Facebook and or on our website. Again, we'll do our best to help steer that because, it's important to us as an industry to do this the right way. Whether you're represented by our firm and or operating outside of our firm, we still want to make sure people are doing it the right way and sharing the information in a way that can be helpful to everybody. And that's why we provide such important content both on our website through YouTube and everywhere else. With that in mind, talking about content, we're going to be looking, I think, at technology plans and some other plans in phase 2. And so this will be a good transition, I think, into the next area of what concerns we have. What is a technology plan? Why don't we share what that is?
So all marijuana facilities in the MMFLA system are required to use Metric. So what your technology plan is it's an explanation of how you're implementing metric into your practices. Specifically, most cannabis companies in other states, and probably most here in Michigan, are going to use some sort of software, not just metric directly, but some sort of software that, if you're a point of sale, works with your cash registers, that works with your inventory tracking. If you're a cultivator, you're going to be keeping track of how many plants you have, what stage of growth they're in, your harvests and batches, etc. So what your technology plan truly is all about is explaining, here's how we are going to make sure our requirements under the seed to sale tracking program and metric are being met. Here's the software we're planning on using, here's how it works, and here's how we're going to stay compliant. If step one's about qualification, step two is about compliance. And the technology plan is specifically how your technology is going to help you be compliant with the seed to sale tracking program.
Oh, no, I was just going to say, Brad, we'll get to your question on about 7411s, and we'll circle back to that. But, Nick, when we see technology plans, I think, on the surface, people might think, oh, I'll just say I'm going to use, metric with BioTrack, and that'll be that. But, as we write these narratives, they're a lot longer than that, aren't they? Right. Tell us a little bit about the depth of what we're seeing as we're preparing those for these clients.
I think it's one thing to just say, what's in the laws and the rules and put that back in a Word document. But it's definitely more intricate, and as far as what the regulators are going to want to see in terms of compliance, they want a step-by-step, exactly the types of procedures and processes that each employee is going to do, how the company overall is going to handle certain things like employee access to the inventory, procedures for loss of access to that third-party system or metric, some required inventory tracking and things that the company is going to do to make sure they're compliant with those rules, and then how they're going to handle acquisitions, and so on and so forth. And it's a lot more intricate, and it's almost a step-by-step layout of exactly how you're going to run a facility every single day to make sure you comply with the rules.
So I think it's a fair statement then that be it technology planning, be it staffing planning, and we're going to talk about those other plans as needed in phase 2, and we've already done another Facebook Live with Barton earlier that talked about the facility planning. But this is where as operators are looking to apply, they got to really dig in and know what their plan is. Mm-hmm. The state wants you to actually do the homework. They want you to just not just, hey, I got a license, now I'll figure it out.
Right.
It's a lot more in depth than that, is it not, Travis?
Very much so. So here's how I like to think about one of these plans when we've been writing them so far. Okay, you as the applicant know you have to implement metric. But eventually, you're going to have a facility. That facility is going to have staff. How does the staff know what the hell they're doing? What is metric? Who has access to metric? What are they expected to do? How are the people with access to metric accountable? What happens in unforeseen circumstances if there's some equipment malfunction and you lose a bunch of product? How does the state know through metric that you entering in a loss is truly a loss and not some diversion outside illegally to the black market? You are explaining first, if you're using MJ Freeway, if you're using BioTrack, or if you're using some other third-party software, okay, how's that work? How do they know metric's going to be, met? Obviously, some of the more sophisticated third-party software are going to make that easier for you, but you still have to explain, okay, here's what we're choosing to do. Here are the different types of staff positions that are going to have different levels of access. Here's how we're going to be training those staff members or owners of our company before they're able to start entering things in. Here's how we're going to make sure when we're receiving shipments of products or when we're traveling, if we're the transporter, if we're the provision center taking products in, that what their metric says and what our metric says make the same sense. Because if there's an issue, well, whose issue is it? If you take in product and you haven't accounted for some loss in weight or some different factors, that might ultimately be your responsibility now should the state have an issue with that disparaging information.
So in other words, if a secure transporter picks up 2 pounds of marijuana to deliver to a provision center, and during the course of the day and a half that it takes to deliver it, by the time it gets there, it weighs in at a pound and 0.9. Mm-hmm. Now all of a sudden we have to figure out where that other 0.1 went.
And if you know that weight loss was in water evaporating or something, you can enter that in. But you're going to have to explain yourself because you're going to be eventually having lots of transactions with other parties, with sales of whatever type of service or products you're providing, depending on your license type. And at a certain point, you might have to explain, okay, on April 20th, 2018, you received a shipment that says it was 18 pounds of product. Well, when we're checking the records of the cultivator you received those products from, they added at 25 pounds. What happened, right?
Right. So, we know within there too, like we're going to have to be providing like waste disposal plans and stuff like that. And how does that interact with the technology plan? I think Travis covered it briefly that you're going to have to do that. But Nick, is there isn't this how we document it?
Mm-hmm. Yeah, I mean, and in that third-party inventory system that interfaces with Metric, you're going to have incident reporting and waste destruction, and those are all kind of baked into the laws and emergency rules that you have to report that, enter that into Metric, enter in any kind of loss, theft, destruction as it relates to marijuana or marijuana products. So it's all going to kind of be integrated into your technology plan and also how you're going to comply with the rules. And kind of to tie together our discussion earlier about the LARA meeting, they did say that there was a kind of a misconception from applicants' point of view that they're going to get their license and then they're going to have the inspections. LARA did say that they're doing pre-licensure inspections soon, so there are some facilities out there that have some build-outs that do have those technology systems in place to be inspected by LARA. So it kind of emphasizes the importance of having all of this laid out in your plans, because then at a certain point in time, LARA is going to have a few pre-licensure inspections and actually see the computers and point-of-sale systems, and that you have all of these things in place that actually are what you're going to say you're going to do.
So I think in the end, as we talk about each one of these plans in phase 2, it's important to recognize that the detail is something that is going to be necessary. Doing the homework is necessary. And Betty, you were asking a little bit about why it's so confusing, and it is an agricultural product. But you know what? In tomato farmers, dairy farmers, they're responsible too for knowing, their output and that their products don't have pesticides associated with it. In this industry, this isn't a money question. This is just doing your homework question. Mm-hmm. And so this is simply about developing plans that are executable and demonstrating your intent to follow the rules. And quite frankly, I don't think it's a money issue when it comes to this. It's doing a homework issue and following through on it. And before we get too far closer to the end of our show today, there was a question I want to circle back to that Brad had asked about 7411s. And for those of you that don't know, 7411 is a statute that provides a plea arrangement for people that have had no other issues on their record that would allow them basically to plead it, and after a year's time, it would be expunged from their record. And what we've seen in that regard is that the FBI knows about it. Just because it was quote unquote expunged, what it really means is it's not held against you in future arrest or anything. It doesn't mean it disappeared from the world. So what we have to do is remind people that you just need to say you had that.
Right. It's important to remember you're required to list your entire criminal history, even if it was expunged or sealed or pardoned or gone.
Or even as a juvenile.
So if you had a 7411, that doesn't mean you're disqualified. That's a disclosure issue. And it was a disclosure issue in the first round of applications that were heard. The problem with the 7411 that was discussed in depth the 2 meetings ago was it wasn't disclosed. Not that it existed, it was that applicant failed to put it in the application.
And there was a presumption that, well, they won't know about it.
Right.
And
there were some other factors going on, and maybe some poorly chosen words in response. But if you have a 7411, that means and you successfully did your year, that means it's expunged. So you don't get disqualified under the statute for having a misdemeanor in the last 5 years, but that doesn't mean you don't disclose it. It still exists, just like if you got arrested. Well, that doesn't mean you were ever charged with a crime. That doesn't mean you did anything wrong. You still need to list it. There's still a record in that police agency that you came in and you were, in cuffs, arrested by the police. And you might have been 100% innocent, but your application requires you to disclose it. And if you fail to do so, and the board believes you knowingly failed to do so, now you have a problem. Not because you were arrested, but because you didn't tell them you were arrested. And that's the issue with the 7411. You're not disqualified, but you need to tell them it happened because they're going to know it's there.
So it's not necessarily the action itself that is at issue, it's the failure to follow up and the presumed cover-up of that action.
I think one of the board members said this is a lot about integrity. You know, we want our applicants, especially in this new industry, given the difference in federal and state law, we want to give these applicants licenses to the most people with the highest integrity that are honest, open, forthcoming, kind of the same general themes going back and forth.
Well, you know, we covered, again, as we always do, a lot of different information here. We do try to keep our shows to about this length, so we appreciate the questions. Certainly there's going to be a lot more information that's going to come out. We know we have another board meeting coming up in the near future. Hopefully we'll see more and more metrics come from them so that we as attorneys that like precedent can actually rely upon that and say, under this fact pattern, here's how we can assume it'll be reacted to. But in the meantime, again, disclosure, truthfulness, and detail is basically the summation of today. When you're doing your plans, make sure you do the homework to know that the work you're doing is going to be something you can execute on. Just because you said you looked into BioTrack THC, but you never actually quoted it out, you never actually signed up for it, doesn't mean you're actually ready for your technology plan.
I mean, the takeaway is this. A technology plan is your opportunity to explain to the state that you know how this all works and you can train your staff to make sure they do it correctly. That's all it is. It's great that you tell the state you're going to use BioTrack. Now prove that you are going to use BioTrack. Prove you're going to use MJ Freeway or whatever your third-party software choice is.
And if it costs you $50,000, show me you have the money. Remember, one thing we didn't really comment on today in the disclosures was the money side of it. It did come up in yesterday or the other day's board meeting. And again, it's the ability to prove you have the capital and prove the sources of those capital and that you can actually perform these plans. It's not just I have enough to say I can get a license, but I have enough to actually do all the things I plan to do to build my facility, keep it compliant, follow the security requirements, follow the technology, and get an operating facility that can remain licensed.
Right. Yeah, because that's the last thing you want to do is to, buff up your plans just for the purposes of impressing the state and then have to follow that and then go bankrupt because of it and fail as a licensee.
That's right.
It's definitely want to make it feasible, and that's where it goes into the planning and understanding your facility, understanding your means of financial resources, and because you can start up any business, but I think the ones that succeed and the ones that have all their ducks in a row are the ones that do thrive and are able to kind of have that down step by step exactly how they want to do it.
Entities have successfully gone forward. Well, we thank you for your time and paying attention and the questions. It's 420 day, so we didn't say happy 420 yet. Enjoy your holiday for those that celebrate. Be safe, of course. Be safe out there. And, for Craig Aronoff and
Travis Copenhaver,
Nick Galendez.
Yes, and we will see you next week at our Cannabis Live. Have a great day, everybody. Be safe.
Hey, guys.